lawyer from Madurai bench, Madras, and his sessions are always slightly different but practical. To understand the exclusion of oral evidence, documentary evidence, and its exception, we thought that why not call Mr. Prabhakar, who has been taking sessions on different perspectives of law, but which have practical nuances to be understood by each and one. And those who have missed his previous webinars can always connect on the BeyondLawCLC, or they can subscribe to the channel for the intakes of not only of the previous webinars of Mr. Prabhakar, but also the other webinars which we have done so far. And on a weekend, to hear from Mr. Prabhakar during these testing times would always be a cherish. You may not go out to a restaurant to eat something, but you will have a food for thought for the mind, which you can always enjoy. Over to you, Mr. Prabhakar.
Good evening, Mr. Vikas, and good evening, friends. Before going into the topic, I would like to share some thoughts with my dad when I entered the profession. One of the foremost advice he gave me was that an honest person doesn't require any document, and for a dishonest person, no amount of document will be enough. This is the essence of oral evidence and documentary evidence under section 59, 60, 61, 62, 3, and then to 91 and 92. The society is such that we not only require document, we require proof. The fact of the matter is that the cases are not decided on the basis of truth, but on proof. Therefore, one may never know the truth, even though we have succeeded in court of law. It's only before the court of Almighty one will know whether we have spoken the truth or not. Section 91, coming to the topic, section 91 and 92 has to be read together. Oral evidence is defined under section 59 and 60. And whereas the documentary evidence is contemplated in the subsequent sections of 61, 60 to 63. But if there is a competition between the two, can the oral evidence overtake documentary evidence? Obviously, documentary evidence should have the preference. Maybe because of the bad faith, treacherous memory. One may say that what has come into a document is the sum and substance of the intention of the parties. Therefore, once it is reduced into writing, then it governs the parties. But there are always exceptions. Every law has an exception and every rule has got a loophole. But the point is, section 91 and 92 has to be taken in together. 91 speaks about the best evidence rule, namely, if you have got the document, then the document has to speak for itself. 91 would say, when the terms of the contract or of a grant or of any other disposition of property has been reduced into writing, a document which requires to be in writing, then no amount of evidence except the document shall be given as evidence or proof of the contents of the document. Therefore, once the intention of the parties have been reduced into writing, this writing will govern the parties or bind the party, and one has to present the document itself or its secondary evidence if it is permissible under section 65. The law says that under section 91, you have to produce the document, or in case where you laid the foundation for receiving the secondary evidence under section 65, you can let it the secondary evidence. There are two exceptions. One is with regard to a public officer required by law to be appointed in writing. When it is shown that any particular person has acted as a public officer, then the document is not required. I can give you a crude example. suppose a judge is acting as a judge for some time, and we know pretty well this man is acting as a judge. Therefore, no evidence or a document is required to show that this man has been appointed as a judge or an officer. The fact that he has been acting as a judge can, in one form or the other, can be proved by many documentary evidence. That is also possible. That is the exception number 1. Exception number 2 under section 91 is in case of a will, if it is probated. Why a will which has been probated is given an exception under 91 is this. Not many people is aware of the fact that once a will is probated in a court of law, under section 294 of the Indian Succession Act, the court is supposed to have the custody of the original will or a copy of it which has been filed. There are some circumstances under which in the Succession Act, you need not file a original. You can file a copy and get a probate for the time being till such that the original is obtained. Therefore, once a probate has been granted, the probate will overtake the recital in the document, and therefore the will which has come into the custody of the court will not be given back to the parties. That is section 294, if I remember correctly. Once it is not given back, the order of the probate or the certificate of probate can be received in evidence as an exception to section 91. Therefore, the sum and substance of section 91 is that it is the best evidence rule. Namely, if I've got the document original, it has to be filed before court. And if you don't have the original, lay the foundation for secondary evidence. And once the secondary evidence is let in, then the party can prove the contents of the document as found in the document itself. That is called as the best evidence rule. But in many cases, the fact that the mere document is filed into court may not give the true picture of what has happened behind the scene. Therefore, 92 has been carved out to say that when the terms of a grant, of a contract or a disposition or a grant is reduced into writing and proved in terms of section 91, then no amount of evidence except the no evidence can be let in to contradict or vary the terms of the contract. What section 92 says is this: when the terms of any such a contract or a grant or other disposition of property or any matter required by law to be reduced into writing to the form of a document, having been proved according to the last section, no evidence of any oral agreement or statement shall be admitted between the parties to any such agreement, such instrument, or the representatives or interests for the purpose of contradicting, varying, adding or subtracting the terms. Therefore, the main section 92 would say that once a document is produced as contemplated under section 91 and has been proved in a manner known to law, why it requires that condition is this: a document, merely marking of a document is not enough, and a document has to be proved in accordance with the law. In case of sometimes it may be section 68 may be attracted with regard to a document which requires a compulsory registry attestation, or a document which is otherwise has to be proved, namely like a sale deed, etc. Once a document which is comes into existence or before the court of law, and it has been proved as contemplated as the section 91, a party cannot let in any evidence to contradict, vary, modify or subtract the terms of the contract. But this is not an inviolable rule. What is the difference between section 91 and 92? Section 91 will apply to all the documents, whether it is a dispositive document or non-dispositive document. unilateral or bilateral documents. Namely, Section 91 will apply to all documents, whereas Section 92 will apply only to bilateral document. One may ask me the question, what is a unilateral document and a bilateral document? The session may not be there, but I'll give you a clue that unilateral document is one person entering into is writing a document, and necessarily a party who is not a party to the document can let in any evidence. Whereas in case of a bilateral documents, 92 will come into play. Suppose you are a will is a unilateral document executed by some person, and once the original is proved, Section 91, that's the end of it. 92 speaks about bilateral document. Why? A person who is not a party to the document, in the later part of this section, what it says, a person or a representative in interest, I think it is Section 99, cannot let in any evidence if he relies upon the document. Therefore, a party to the document is bound under Section 92, and therefore he cannot let in normally an evidence to contradict or vary the document. But 91, in respect of all documents, it also applies to a will or a gift, unilateral documents. And in such cases, a party who doesn't want to go by the document is certainly entitled to give any evidence unaffected by Section 92. Straight away, I would like to draw the decision reported in 1958 AIR Supreme Court, page 448, by Hira Devi versus Official Assignee, Bombay, where the Lordship would make a distinction between Section 91 and 92, which in fact I remember correctly in 2003, Arijit passage, His Lordship Arijit passage has also echoed that 91 applies to all documents, either unilateral or bilateral, whereas Section 92 applies only to bilateral document alone. His Lordship Arijit Pasya's judgment speaks about the best evidence rule. What is the best evidence rule? Section 91 is the best evidence rule. Namely, if you have got a document, you have to file the document and prove it. No other evidence is possible. You cannot let in any oral evidence or a parole evidence to prove otherwise. Therefore, it is called as the best evidence principle. In some cases, it is also, it is not a procedural law, it can also be a substantive law. We'll come there later. Of His Lordship Arijit Pasya's judgment was reported in 2003 6 SEC, page 595. Roop Kumar versus Mohan Tedani, 2003 6 SEC, page 595. Where Lordship would say that Section 91 speaks about the best evidence rule. The third judgment is of very recent origin. V. Anandaraj versus T.M. Narasimhan, 2021 Supreme Court, page 640, Supreme 2021 Supreme Court 640. What it would say, in fact, there is a statement which Arijit Pasya has also echoed, namely, there is a presumption under law that when there is a writing, that writing is full and final statement of the intention of the parties to avoid future controversy, bad faith, and treacherous memory. Can say, therefore, once a document comes into play, or the parties have reduced their intention into writing, this has to be presumed that they have reduced it into writing to avoid future controversy, bad faith, and treacherous memory. What is future controversy to avoid? Suppose you reduce all the terms of the contract, and this contract you say is the proof of all the terms and conditions of a contract between the parties. If you agree orally, and there is nothing in writing to show to court or somebody else then the controversy may erupt. This is called as a future controversy. To avoid future controversy, if the document is there, anybody can read it. What are the terms and conditions? Secondly, bad faith. What is bad faith? It is all pervading in India. That a person who enters into some contract or executing a document, going back upon the document, he can take all the pleas under the sun and sundry. Namely, he can very well say that the document is voidable. He can very well say that the document is void. Even can very well say that it is voidable because it was obtained on coercion, duress, misrepresentation, fraud, mistake, etc. These are called as bad faith. And what is treacherous memory? Suppose a person enters into a contract orally. Treacherous memory, lack of memory is one thing and treacherous memory is another. Lack of memory is a genuine lapse of recognition what has happened earlier. But treacherous memory is the word which is used by the courts insofar as section 92 is concerned. Treacherous memory is that you know it for certain that what has happened, but still you want to go ahead and prove something else, or to show to the court by way of a diversionary tactics that what has happened the other day is not the true picture, it is not the correct picture, I want to give a different version. This is called as a treacherous memory. Therefore, once a document comes into play, the presumption is that it is a final statement of intention of the parties, and it is to avoid future controversy, bad faith, and treacherous memory. To kill a person in a court, that you can't, or shut the person from a court to, you can't lead in any evidence which is nonsensical in nature or stupid. It is the document which covers, but it's not the everything. There are exceptions to section 92. The Provisos, in fact, has ruled the rose for several decades, probably from 1870s or even beyond that, before even the advent of the Evidence Act. The first of the Proviso would say, any fact may be proved which would invalidate any document or which would entitle any person to any degree or order relating to that too, such as fraud, intimidation, illegality, want of due execution, want of capacity in the contracting party, want or failure of consideration, or mistake of fact and law. Insofar as mistake of fact and law is concerned, you are also aware under the contract, such a contract, if it is based upon a mistake of fact, it is unenforceable. But in case of a mistake of law, ignorance of law is no excuse. But what this proviso would say is that if a document has been obtained by fraud, intimidation, illegality, want of due execution, want of capacity in the contracting party, failure of consideration. We will take one by one. What is fraud? Chengalmurayan's case would say that a person who knows it for certain and did not reveal the same at the time of entering into a contract is assumed to have committed a fraud. Fraud unravels everything. Once a document is challenged on the ground of fraud, then it goes to the root of the matter. In fact, Chengalmurayan's case echoed the principle enunciated by Lord Coke several centuries ago. Fraud unravels everything. And subsequently, in a couple of judgments, also in the latest of his lordship, Arun Mishra also spoke about this fraud. Once a document is challenged on the ground of fraud, then the shackles or the section 92 or the bar under section 92 will not come into play. Namely, if you want to vary the terms of the contract or contradict the terms of the contract, Normally, you can't do it. But if you say that it has been obtained under a fraud, what is a fraud is a question of fact. It may be misleading the other party to enter into a contract or suppressing a material factor at the time of entering into the contract, which the other man was not aware of, and unwittingly he has entered into or signed the document. Then he can very well say that it has been obtained under a fraud. Illegality. The section 16 to 22 of the Contract Act speaks about this misrepresentation, fraud, coercion, etc., and undue influence. My point of view is, even though this section 92 Proviso doesn't speak about undue influence or coercion or misrepresentation, it speaks about only fraud. I am of the view that all cases covered under section 16 of the Contract Act will be governed under the Proviso. The reason is, it's not only fraud, it speaks about intimidation. Intimidation is a larger concept where coercion, which is we can find under the Contract Act, would fit in. Namely also illegality. Any contract based upon undue influence or misrepresentation is illegal. Therefore, rest assured that whatever the plea which you take in case of that contract is voidable, then this section or the proviso can come into play that you can let in any evidence to show that there was the intention of the parties was not correct. The second aspect is want of due execution. Suppose I say that I have not even executed the document. Am I bound by the document? Normally, day in and day out, we are doing the very same thing. Namely, one party comes to the court and files the document, the other party takes a stand that it is bogus, fraudulent, fallacious, fictitious, etc. And these types of pleas are permitted, subject of course to proof, which is a different thing. But the point is, once the document is challenged for want of due execution, then the party is not bound by section 92. In many cases, this has been taken into account to show that if a party challenges the document, then he is not bound by the dictate of section 92. He will always come within the first proviso. I will come to the some of the judgments thereafter. The second point is want of capacity. What is want of capacity? Want of capacity is nothing but incompetency to enter into a contract. What is incompetency? An insane person, a minor, or an insolvent. If he enters into a contract, then the contract is void from the inception. Therefore, the party who has entered into the contract must have the capacity or the competency to enter into a contract so as to bind. If a party, a minor, assuming for a moment, a minor enters into a contract and this minor wants to challenge the document on the ground that on the day when I have executed the document, I was only a minor and therefore I am not bound by the document. Everybody is aware, under the Indian law, there is a distinction between the English law and the Indian law. It is not as though in all cases, the minor, a contract entered into by a minor is void. A contract entered into by a minor is void if it is not in the interest of minor. Suppose a minor enters into a contract like a promissory note. He lends the money. Can anybody say that a minor is not entitled to recover the money because he was a minor and therefore the contract is a void? It is for the beneficial interest of the minor because he lent the money. Therefore, he is entitled to recover. That is the slight distinction between the Indian and English law. My point is, want of competency, whether it is an insolvent or an insane person or of unsound mind, and secondly, a person is a minor. In cases of incompetency with regard to insane person or insolvent, the burden is upon the person who challenges it. But if a person challenges a document that he was only a minor at the point of time when the document was entered into or executed, then the person who relies upon the document must prove that the person who has executed the contract, executed the document was not a minor at the point of time. Therefore, it is a valid contract. Many a court has committed an error thinking that if a document is challenged on the ground that a person is a minor, the person who challenges the document must prove the same. It is not so. On the other hand, if a person comes to the court and says that I was a minor, therefore the document is unenforceable and void, a person who relies upon the document, no, this is the person who has executed the document was competent to execute on the day when he was executed. Therefore, the burden is upon him. Please do remember that a minor's contract, if a person comes to the court and says that it is a minor entering into a contract, the person who relies upon the document, I think if I remember correctly, it is a 1967 Supreme Court. The next aspect is want or failure of conservation. Why two words have been used? One is want of conservation and another is failure of conservation. Want of conservation is no consideration passed under the document or consideration as stated in the document as not passed. Failure of consideration is something else, namely, on the date of entering into the contract, assuming for a moment a sale, a person gives a check for the consideration. The check has been stated as a consideration for the document. And after the completion of the contract or the registration of the sale deed, the check bounces. There is a failure of consideration, not a want of consideration, because the consideration which was stated failed subsequently. The law took into account that it is not merely a question of want of consideration, but a failure of consideration also will come into play in such cases. A person is entitled to let in evidence. Or then loss is the mistake of fact or law. Ignorance of law is no excuse, but ignorance of fact is excusable. The reason is, every person must know the law, or otherwise somebody will commit a murder and say that I don't know law, that I will be held criminally responsible for murdering a person. A crude example. Whereas in case of a mistake of fact, a person who was not aware of the factual matrix or a factual backdrop enters into a contract, or the other person misled him to enter into a contract by suppressing a material fact which was not aware at the time when the contract was entered into, or a person was, both the parties were not aware of a particular fact. A mistake of fact can be on either party or on both the parties. And if it is on both the parties and if it is beneficial to one and another who it is detrimental to another, the person who is, to whom it is detrimental can always come and challenge that there was a mistaken impression of a fact, and therefore what I have entered into was never thought of if this fact was known to me at the time when the contract was entered into. The second and the third proviso, third and the fourth proviso, second and third proviso speaks about two things. The existence of any separate oral agreement as to any matter pertaining to the document, and if it is not inconsistent with the terms of the contract, and if it is the contract is silent. Suppose the contract speaks about a particular thing, but other terms are not clearly spelled out in the contract. Can I let in any evidence to show that what is silent is this? I will give you a crude example. There were two houses, adjoining houses. Between the two houses, there was a lane. For the beneficial interest of both the person, a lane was left. At the time of registering the sale deed, what has been found was that they have given that you have got a right over the lane, which is in between the two houses. Both the documents speaks about that. Or assuming for a moment, one of the party who purchased the property speaks about on the right to use the lane on the western side. To the further west is the other man's property. The document is silent with regard to the measurement of the lane. It is length and breadth of the lane or the width of the lane is the document is silent. But the document speaks about a lane alone. Can you let in any evidence, oral evidence, that in between the two houses there is a lane in existence for time immemorial, and this lane measures 6 feet in breadth and 100 feet or 50 feet in width, which is being spoken to in the document? To my mind, this is the document speaks about a lane, but it does not speak about the length and breadth, which are the vital terms of the contract. Suppose the document doesn't speak about the length and breadth, etc. Can we mean to say that the document doesn't speak about the length and breadth? Therefore, a person is not even entitled to the lane at all. That will lead to a stupid result. Because the intention of the parties is to be seen. Sometimes, if the document is silent, then you are supposed to give some oral evidence to buttress or fortify your case. But do remember, this is different from a case where the lane has been shown to be 3 feet breadth and 50 feet in length. You want to give an evidence that no, the length, the breadth of the lane is not 3 feet, it is 6 feet. You are barred under section 9 because the terms of the contract speaks about the lane as 3 feet width. The term of the contract is width of the lane is an important term of the contract. Therefore, when the document speaks about the breadth and length of the lane, you cannot let in any evidence. The reason is it will be varying the term. If the document doesn't speak about the length and breadth, you are entitled to let in any evidence to show that this is the length or the breadth of the lane. The another proviso is a subsequent agreement. We speak about a separate oral agreement as to any other term which is in which the document is silent. That is a proviso number 3. Proviso number 4 is the existence of a distinct subsequent oral agreement to rescind or modify any such a grant or disposition of the property or a contract may be proved except in cases in which such a contract, grant or disposition of the property is required by law to be in writing or has been registered according to the law for the time being in force as to the registration of the document. This requires some explanation. If a document which is required in law to be reduced into writing and you have got a parallel document or a contemporaneous or a subsequent oral agreement to modify or rescind or vary the terms of the contract, you cannot do it except by another registered document. I give you an example. Suppose the terms of the intentions of the parties, the terms and conditions have been drawn and a document has been executed. This document under law requires registration and it has been registered. And you want to change the terms of the contract by a subsequent oral agreement between the parties. If the first document does not require registration, then a oral contract or a oral agreement or even a written agreement which is not registered can be proved. But in cases where the original contract mandatorily requires registration, say for example a sale deed or a gift, then if you want to change the terms of the contract, you cannot do by oral agreement between the parties. It can be done only by another registered document. I think I will make myself clear. If a document has been reduced into writing and registered, if a law requires it to be registered, you cannot let in any oral contract or an agreement or even reduce into writing unless this subsequent oral agreement is also reduced into writing and registered in accordance with the law. A registered document cannot be modified or varied unless by a document is registered subsequently. This has been pointed out in AIR 2000 Supreme Court, page 2633. Saktivel versus Venugopal Pillai. AIR 2000 Supreme Court, page 2633. I have got a different opinion on this case, but I will canvass it before this forum. There was a case where 4 persons were given a property by way of a settlement or a gift deed. There is a difference between a gift and settlement. We will take it for this discussion. But on facts, it was a settlement deed. A settlement deed was executed by one A in favor of 4 minor persons, minors, represented by a guardian. Say, for example, B, C, D, and E. A executed a settlement deed in favor of 4 minors that has been accepted by the guardian and acted upon. Subsequently, one of the minor, after becoming a major, files a suit for partition. The defendants or the other 3 persons took a stand that it is of course so that was a settlement deed. All the 4 persons got right under the settlement deed, but subsequently, the plaintiff who has filed a suit for partition received money and orally relinquished his right in the property. And therefore, he is not entitled to any share in the property. The trial court thought that this is a subsequent event. Therefore, the party can let in evidence and permitted the parties to let in evidence by citing a section 90, exception to 92, or being as evidence which has happened subsequent to the document. Unfortunately, the suit was dismissed on the ground. The court believed that there was a oral understanding by which the plaintiff relinquished his right. I'm not sure about the full factum of the case, but the judgment would show that the trial court accepted the evidence of the defendant. We will go by there should have been some evidence, otherwise the trial court would not have concurred with the case of the defendant that they have paid money to the plaintiff and the plaintiff has relinquished right. The matter went to the High Court by way of a first appeal. The learned judge thought that it is barred under section 92, and therefore he has decreed the suit, reversing the judgment. The learned High Court judge thought that this was a case where there was a settlement, and the proviso number 4 speaks about a subsequent oral agreement cannot be brought in evidence. If the original contract is a registered document, it can be subsequently modified or varied by another registered document. And this is a oral evidence which the defendant wants to give, and therefore the trial court judge was wrong. By way of letters patent appeal, I think it was before 2004, the letters patent appeal, the division bench of the Madras High Court also concurred with the single judge and has held that it is barred under section 92. The matter went to the Supreme Court. The Supreme Court concurred with the High Court, stating that there is a settlement. Under the settlement deed, 4 persons were given right. And if you say that one of them received money, then it will vary the terms of the contract. Quite unfortunate. If you go through the judgment, it has not referred to any of the judgment of the Supreme Court or any other judicial precedent. It took into account on a mistaken impression of law that when the defendant wants to let in evidence, they want to vary the terms of the settlement. The settlement speaks about 4 persons entitled to a share in the property in equal quantity. And if you say that instead of the property, the money was given, then it will vary the terms of the contract. Forgetting for a moment that the case of the defendant is not that instead of the property, minor was given money. If you go and see verify the facts of the case of the defendant is very simple. Yes, of course, there was a settlement. Under the settlement, 4 persons were entitled to the property, true. All the 4 got the properties, and subsequently the people became major. After becoming a major, the plaintiff received money in lieu of his share in the property and relinquished his right. In my view, this is not varying the terms of the contract. In this case, section 92 will not come into play at all. Section 92 will come into play if I want to let in evidence that on the date of the document, 4 persons are entitled to under the document if you read it. But a subsequent oral agreement that has not been done, instead 1 person was given money rather than a share. That is not the case. The case of the defendant was that subsequently all the 4 entitled to the property, and after becoming a major, we paid in money. What is wrong in letting in evidence? Under the a co-sharer can receive money and relinquish his right, or is it in a case of a partition, there are 3 stages, and in respect of delivery of possession, or in respect of a division in status, or in respect of meets and bounds. There are 3 stages in a case of a partition. One is division of status. Second is division by meets and bounds. Severance of status is the first stage. The second stage is actual division by meets and bounds. The third stage is delivery of possession of property. In respect of the first and third stage, no document is required. Only in respect of the second stage, where there was a division by meets and bounds, a document is required. And if the document speaks about the instant division of the properties or in presente, then that document requires registered. But still, if a person can, with an unregistered document of a partition or memorandum of partition, can come to the court and prove the first and third without the document being registered, namely severance of status, and secondly, delivery of possession. Actually, I am in possession in pursuance of the severance of status. If of the three, two can be stitched together, a partition can be proved, even though the document is not registered. But the Honorable Supreme Court failed to consider this fact, namely, it is not changing the terms of the contract, but it was entirely a different transaction altogether. It has nothing to do with the settlement deed. Subsequently, long after the person becomes a major, got money, went out. And in my view, that the trial court was right and all the three courts, namely the single judge or the division bench of the High Court, as well as the Supreme Court, was wrong in taking into account that this is a settlement, and in pursuance of the settlement, there was an oral arrangement, and therefore the evidence is not admissible. This judgment is reported in AAR 2000 Supreme Court 2633 Saktivel versus Venugopal Pillai requires a revisit by the Honorable Supreme Court. Coming to the other aspect, if a document, intention of the parties is to execute one document, but what has been done was some other document, is it possible to prove the same? Normally, a sale deed and an agreement to repurchase and a mortgage by conditional sale. These are things which were happening in the earlier part of the 20th century, and now it is not a big thing. But the point for consideration is, before 1929, there was an amendment before 1929 of the Transfer of Property Act. If there was a sale and agreement to repurchase in two different contemporaneous documents, namely, at this, you register a document, on the same day you enter into some agreement. It is possible to prove it by a subsequent agreement. But after the amendment in the Transfer of Property Act in 1929, unless and until these two conditions, namely the sale as well as the agreement to repurchase, are embodied in a single document, you cannot let in any evidence. The oldest case, Balkishan Das versus Leghi, ILR 22, Allahabad. It is in respect of a Privy Council case. Balkishan Das versus Leghi, ILR 22, Allahabad, Privy Council, page 149. Balkishan Das versus Leghi. There was a case of a sale and agreement to repurchase, whether it amounts to mortgage by conditional sale. What is a mortgage by conditional sale? Or a difference between an agreement, sale and agreement to repurchase. Sale, there will be an immediate transfer of ownership. And then if you enter into an agreement for repurchase, it is a new contract. Till such a time that the repurchase happens, your right in the property goes to the other man. But in case of a mortgage by conditional sale, the right of ownership will be with the vendor. He will be in possession of the property, or he will be enjoying the property as a owner, with a condition that after some time the document will take into effect as a sale. For a time being, it is a mortgage, and then subsequently it becomes a sale. But on the face of it, if the document speaks about that it is only a sale deed, can you let in evidence that it is not a sale but a mortgage? Mortgage is a condition. There are no terms about the conditional sale or a repurchase. Simply it is a sale deed. You want to let in evidence that no, what I have entered into is not a sale, but it was only a mortgage. That is not permissible under law according to the Privy Council. Coming to the Next aspect, Nanjappan versus Ramaswamy, 2015, 14 SEC 341. Nanjappan versus Ramaswamy, 2015, 14 SEC page 341. It was a case of a specific performance of a contract. In that case, the defendant wants to take a plea that the consideration as found in the agreement of sale is not true. It was for a larger consideration, but we have entered into this contract to avoid a stamp duty. I'll give you an example. Suppose a person enters into a contract, think that is only for 10 lakhs. But the value of the property or the real agreement between the parties is 30 lakhs. But to avoid stamp duty, they want to put it as the guideline value or a circle rate as 10 lakhs. The court said that you can't let in any evidence for a lesser consideration. But what you can let in is that the market value of the property is different from the value which is entered into contract. It is a specific performance is based upon an executory contract, and it is not an executed contract. Therefore, the discretion lies with the court whether to enforce the contract or not. In the doctrine of lucky purchase will come into place with all force in respect of a sale deed. Once a sale deed is completed, it becomes an executed contract. In such a case, you can't challenge the document on the ground that the consideration paid was far less, unless you come within the four corners of fraud. But in case of a suit for a specific performance, if the value of as found in the agreement of sale is far less than the market value of the property, you can let in the evidence to show that even though the value as found in the agreement of sale is 10 lakh, the value of the property is several folds. It's 30 lakhs or 40 lakhs, and therefore it is not a fit case for exercising the discretion for ordering specific performance. But in the case of Nanjappan versus Ramaswamy, what has happened was the party wants to let in evidence that the contract, the amount put in the contract are stated in the contract as a consideration is to avoid stamp duty, which was not acceptable to the court because this is not a valid explanation. It will vary the terms of the contract. K.S. Narasimhan versus Indo Commercial Bank. AR 1965 Madras page 147. K.S. Narasimhan versus Indo Commercial Bank Limited, AR 1965 Madras page 147. It was a case where a different consideration than what has been found in the contract cannot be pleaded. But total want of consideration can be pleaded. I said that the first exception of the Proviso number 1, when I read it, it says that a want or failure of consideration is a ground for letting in evidence. You can say that agreement of sale or in fact a sale deed, what I have received is not the amount found in the contract. Suppose the sale deed says it is 10 lakhs. Even though they have to pay 10 lakhs, they have not paid, I have received only 5 lakhs. That is not possible to challenge the document. But the document can be challenged in some other way, namely, there is a total want of consideration. Namely, I have not received a single point because the contract without consideration is void. At the same time, the English law would say that applying the peppercorn theory, that even a pepper or a corn can be the consideration for a transaction. Therefore, a small amount of consideration stated in the document is not of an issue. Doctrine of a lucky purchaser will kick in. But if you have not received the consideration at all, then you can let in evidence that no consideration has been received. How it can be done? Assuming for a moment, which I have stated earlier, a document accompanied by a check for a consideration, and this check bounces. You have not received any consideration at all. Then you can challenge the document for want of consideration. But at the same time, it is highly doubtful to say that the document says 10 lakhs, I have received only 5 lakhs. Total want of consideration is different from showing I have received only a part consideration. Even though there is one judgment of the Bombay High Court, one of the old rulings, which I remember, that in cases even a part consideration alone has been paid as not what has been stated can come within the proviso, but majority of the view of the High Court would say that the total want of consideration can be pleaded, but want of portion or part of consideration cannot be pleaded. It is a bar under section 92. The next judgment, a very interesting judgment of His Lordship Sulaiman of Allahabad High Court. One of the greatest judges of pre-independence era, His Lordship Sulaiman. To go and read the history, it will say that this man was a judge at the age of 34 or 35. And at the age of 49, he quit the profession. As a judge, resigned because it was enough for him. At the age of 34 or 35, he became an High Court judge. 49, he resigned because he has got some interest in literature and went off. Go and read his judgment, one of the finest judges in my view of the pre-independence era. Muhammad Taqi Khan versus Jung Singh. AR 1935, Allahabad, page 529, a full bench judgment. Muhammad Taqi Khan versus Jung Singh. AR 1935, Allahabad, 529, full bench. That is a case where the oral evidence, when it can be let in, was considered by the full bench. It came to conclusion on 3 points it was referred, but on 2 points it has answered, namely, no evidence that sum is not payable is admissible. No evidence can be let in that what has been stated in the contract is not payable. Suppose I have to pay 1 lakh under the contract. I cannot say that it is not payable. That is barred. Because there is a contract. If you say that the contract is true, I have entered into, but I am not liable to pay the amount as found in the contract, there is a bar. Second, receipt of consideration is not part of the contract. I can take a very well a clue in respect of Shaktivel's case where I said that the Supreme Court went wrong. It should have reviewed because the case has nothing to do with the 92 because it was a subsequent event, not a subsequent agreement. In this case, what the Lordship would say that receipt of consideration is not part of the contract. Namely, a contract said that I have to pay money. Subsequently, I pay money for which a receipt has been issued. Whether this receipt forms part of the contract? No. Therefore, insofar as the money as found in the contract, whether paid or not, if I produce a receipt, this is admissible in evidence. There is no bar at all because it has nothing to do with the contract. It is a subsequent event and not a subsequent contemporaneous agreement. It is to discharge the liability under the contract. If it is to discharge the liability under the contract, and if you produce a receipt, this is perfectly admissible under law. And third, not open to a mortgagor that the transaction is not for the sum stated, but open to him say that he has not received money. These are the 3 points which our Lordship has answered. If there is a mortgage, you cannot let in evidence that the mortgage is for 1 lakh of rupee, which is stated in the mortgage. You cannot let in evidence against the value or the consideration found in the mortgage. Even though the mortgage says 1 lakh, I have received only 50,000. There is a bar under the act. But he can say that he has not received the money at all. What does it mean? It is not for him to contend that the consideration as found in the contract is not the consideration, because you will vary the term. The contract says that the mortgage is for 1 lakh of rupees. You cannot say that this is not the value. But it is always open for him to say that I have not received that consideration, for which you can let in evidence. What are the 3 points which as Lordship Sulaiman has said? You cannot let in evidence that sum is not payable under the contract. Mortgage says that you have received 1 lakh and you are liable to pay 1 lakh. You cannot say that I am not liable to pay for some reason. 2, if there is a receipt for consideration, that receipt is only in discharge of the contract. It is not a variation of the contract. 3rd, you cannot let in evidence that this is not the sum for which we have agreed, but you can always say that you have not received the money. Kindly bear in mind that this is one of the finest judgment on section 92. Go and read, get the grip on the subject. The next is Sangli Bank versus Bimappa, 2006 AAR Karnataka, page 488. Sangli Bank Limited versus Bimappa, AAR 2006 Karnataka, page 488. There is a very interesting case, a promissory note, and it has been filed that the defendant has not paid the money under the contract. The defendant comes and says that subsequent to the contract, there was a contract between, or an agreement between the parties that this money is not payable till the happening of an event or a certain event, or you take any event. I can crudely say that it is not as found in the case law. I can give you a crude example that even though the contract was entered into, assuming for a moment it was for the education. Subsequently, I want to let in that I am only an engineering student for which I borrowed money. There was an agreement between the parties to say that till such a time I get some employment or completing the course, the plaintiff is not supposed to file the suit on the basis of the promissory note. According to the Karnataka High Court, this evidence is admissible in evidence. Proof is something else, but it says that this type of oral subsequent contract is admissible. Why? Proviso number 3 says that any oral agreement is admissible in evidence. The only rider is if the first document is a registered document, then the terms, the variation should also be by way of a registered document, as it was held by the Supreme Court in Saktivel's case. But a promissory note doesn't require registration. Therefore, any subsequent oral agreement to change the terms can be let in if the document is not registered. That is the sum and substance of the judgment in Sangli Bank's case. And then conduct of parties. What is conduct of parties? Many a case, the intention of the party is one, but ultimately the document which has been drawn up may be something else. There can oral evidence can be let in to show that this is a different type of a document. I will rush to the one judgment, Prionath versus Madhu. This is one of the oldest judgment, 1898, 25 Calcutta, page 603. Prionath versus Madhu, 1898, 25 ILR Calcutta, page 603, full bench. That the intention is only to execute a mortgage rather than the sale deed is not admissible in evidence. As has been said, I have taken the earlier case of Muhammad Taqi Khan. Their lordship would say that on the face of it, it says that it is a sale. You cannot let in evidence that what I have intent to execute is not a sale but a mortgage. This is not permissible. But there are judgment would say that the character of the document is different from what has been intended to be executed. Then I can file a suit challenging the document as void. If you take the stand that this is a void transaction, namely the exception within the four corners of fraud, then you can let in evidence. 1968 Supreme Court would say that if the character of the document is different from what has been intended to be executed. So therefore, if you say that it is not a sale, I have been misled thoroughly, the other side has committed a fraud in bringing up a sale deed instead of a mortgage, that is a different story. But if it doesn't come within the four walls of fraud or intimidation, etc., and the exception, and if you simply want to let in evidence that even though this is a sale, on the face of it, don't read it as a sale, read it as a mortgage. That is not possible, and it is prohibited. That's the oldest of the judgment. The next judgment is so beautifully narrated by His Lordship Melville of the Bombay High Court. Bakshu Lakshman versus Govinda Kanji, 1884, Bombay 594. Bakshu Lakshman versus Govinda Kanji, 1884, Bombay 594. What it would say is, there is a difference from letting in evidence and by disproving a case by the conduct of the parties. Namely, you cannot start the case by letting in evidence that this is a different type of document. But you can let in evidence that subsequent to the document, you see the conduct of the parties. It is not the document which was as typed or printed, but it is different, yes, transaction different altogether. What you say is, you cannot let in evidence on the face of it, sale deed is there. You want to say that I have not executed a sale deed, but it is a mortgage. You cannot start by giving evidence that it is not a sale by a mortgage. But it is open for you to say that by the subsequent conduct, it was only a mortgage. How it can be shown? If it is a sale, there was a transfer of ownership, then delivery of possession. You can very well say the ownership didn't change. Possession is me. It all shows that it was only a mortgage. And there is also a possibility a part of the mortgage money was received by the purchaser. These are some types of evidence which may crop in any case. Namely, on the face of it, it is a sale, but in reality, it was a mortgage. I can't let in evidence that it is a mortgage and not a sale. But I can let in evidence that subsequent to this document, kindly see the conduct of the parties. One, possession is with me. He should have taken possession. Yes, not taken possession. Two, I have paid some money towards discharge of my mortgage, for which there is evidence. Three, there was no transfer of ownership. You see the revenue records. Katara Padma stands in my name. I continue to pay the tax receipts, etc. These will show the conduct of the parties subsequent to the document. Whereas Lordship Mill will say that this type of conduct of approving the conduct of parties subsequent to the document ultimately will end up in throwing the document as a sale and concluding that it was a mortgage. What you cannot achieve directly can also be achieved indirectly by the conduct of the parties which are subsequent to the document. Kindly keep in mind this judgment has been referred to by very many judges. I'll give you another judgment. Rakan versus Alagappa Udaya. Rakkan versus Alagappa Udayan, 1892, 16, Madras, page 80. 1892, 16, Madras, page 80. This is the judgment of the first Indian High Court judge, His Lordship Mutswami Iyer, where His Lordship Mutswami Iyer accepted the proposition laid by Melville in the case of Bakshu Lexman, where His Lordship wholeheartedly accepted the principle that the document per se, when it says sale, you cannot let in evidence to start with. That evidence is prohibited. But at the same time, the subsequent conduct of the parties can be let in, and then it is for the court to judge whether it was a mortgage or a sale. That is possible under law. Then next is, if a document is sham and nominal. Always in many cases we use that if it is a sham and nominal, we can let in evidence. Ishwar Das Jain versus Shohan Lal. AAR 2000 Supreme Court page 426. AAR 2000 Supreme Court page 426. Equivalent 2001 SEC page 434. Ishwar Das Jain versus Shogun Law. A mortgage is executed only as a security. The court has held the intention of the parties has to be seen. You can let in evidence that the document, even though was executed, even though it speaks about a mortgage or a sale, it was only a security, not for due repayment of any money. This is possible. You can let in evidence. But in that case, on fact, the court disagreed that there is no evidence on record to show that it was given only by way of a security. On facts is different, but on law, it is possible for a person to show before the court by letting in evidence that even though it was a mortgage, it was only executed as a security. Suppose you say that an agreement or a contract, I have not executed at all. That Proviso also speaks about that. If you have not executed the document, if you are challenging the document that you have not executed, then you are entitled to let in evidence on that score. I will rush through three judgments. One is AIR 1982 Supreme Court, page 20, Gangabai's case, followed in Roop Kumar versus Mohan Tadani in 2003 Supreme Court, and then of the very latest judgment of Placid Francisco Pinto versus Jose Francisco Pinto, 2021 8 MLJ, Supreme Court, page 565. Placid Francisco Pinto versus Jose Francisco Pinto, 2021 8 MLJ, Supreme Court, page 565. This Placid Francisco Pinto relied upon Gangabai's case, namely, the bar is only for a person who relies upon the document. Section 99 speaks about that parties and the party successor in interest are barred by Section 92, provided to rely upon the documents. Suppose you say that I have not even executed the document. If you say that you have executed the document, you say that it is a different transaction, altogether it is entirely different. You have to fit in your case within the proviso. But you say that I have not even executed the document. You challenge the document. Therefore, a person challenging the document is not bound by it, and therefore he can let in any evidence. Then two important issues before I go to ambiguity. Possessory mortgage to simple mortgage and simple mortgage to possessory mortgage. There are a lot of confusion. A possessory mortgage or a usufructuary mortgage, as we legally called as, possession is an important component of the document. A person wants to come forward and say that even though the document speaks about a usufructuary mortgage, I continue to be in possession of the property. Therefore, it is not a usufructuary mortgage in a true sense of the word, but it was only a simple mortgage. Can he let in evidence? AIR 1933 Privy Council, page 178. Mon Feroz Shah versus Shobat Khan. Mon Feroz Shah versus Shobat Khan. AIR 1933 Supreme Privy Council 178. That is a possessory mortgage. Possession is a term of the contract. In all usufructuary mortgage, possession is a term of the contract. No evidence is admissible to show that the possession was not given, even though you have actually been in possession. But you cannot let in evidence that it is not a usufructuary mortgage or a possessory mortgage in a true sense of the word. But what has happened is only a simple mortgage, you are bought. But converse, I will come there. There are two interesting judgments. Can a person who says that there is a simple mortgage, and in a simple mortgage in lieu of interest, possession was delivered to the party? A simple mortgage, the terms of the contract will be like this: amount, period of time, or if the period is not there, from the date of the document, and then interest to be payable. A person files a suit on a simple mortgage. The other party comes to the court and says that in lieu of interest, I have placed the plaintiff in possession of the property. Therefore, I am not liable to pay the interest. It is not the mortgage money that is under consideration. There are two components. One is the principal and another is interest. The defendant comes and says that principal is true, but I have to pay. But in lieu of interest, I have placed the other man in possession of the property. Can this evidence be let in? Is it permissible under law? Even though there is no confusion during the earlier part of the 20th century, there was some confusion before the Madras High Court in two judgments of His Lordship Delhi and of no less person than His Lordship Sampath. Both of them committed a gross mistake in saying that in case of a simple mortgage, you cannot let in evidence. One is in 1988, One Law Weekly, page 488, and another is 1998, the MLJ supplement, where His Lordship Sampath would say that the evidence is barred. But the fact of the matter is this: both the judgment, in my humble view, are wrong because the correct legal position has not been placed before the court. In case of a simple mortgage, no doubt interest has to be paid. Everybody is aware consideration can be in kind or in cash, unless the contract says that the consideration should be in cash. Many of the documents would say that the interest has to be paid at a particular rate. It doesn't speak about kind or cash. We assume that it is to be in cash. But when the document is silent, how this interest has to be paid? Under Indian law, the consideration can be either kind or cash. Kind means I can put the other man in possession of the property in lieu of interest. This judgment, two judgments are on that point. Collector of Etta versus Kishore Lal, AIR 1930, Allahabad, page 721. Collector of Etta versus Kishore Lal, AIR 1930, Allahabad, 721, full bench. Payment of interest is not varying the term of the contract. It is only discharging the contract. It is not varying the term. If you want to discharge the contract, it is not varying the contract. Therefore, you are entitled to let in evidence on that score. That was a full bench judgment. This judgment and the subsequent judgment which I am going to refer were not referred to by before His Lordship Delhi and His Lordship Sampath. The second judgment on that aspect is Shahib Din versus Danuk Darji. Shahib Din versus Danuk Darji, AR 1948, out 129. People in North India knows about South. In South India, people think the South is nowhere in India, it is in Pakistan. The problem is that, if I remember correctly, how the High Court was somewhere in Agra, subsequently AR 1948, out the page 129. Interest can be paid either in cash or kind. Putting in possession is permissible under law. These two judgments have not been referred to. At the time of pronouncing the judgment by his Lordship Belly, he has referred to AR 1933 Privy Council, which I have referred to, namely Feroz Shah's case. It was a case of a usufructuary mortgage where possession is a term of the contract. That cannot be taken as the yardstick for saying that in a simple mortgage also, the interest cannot be paid by placing in possession. Placing in possession in lieu of interest is permissible under law. Then, how about a degree? Can a degree be changed by a contract of parties? Adappa Papamma versus Dorba Vengaya, AR 1935, Madras, page 860. AR 1935, Madras, page 860. Where the two parties enter into some arrangement, they want to vary the term of the degree. The court said that it is not permissible. The reason is this: it is not under section 92. It is more of a procedure in nature and not a rule of evidence. Simply because law permits the modification of the degree in one form, by way of review or under section 152, etc. But you can't, by an act of parties, cannot change or vary or modify the degree of the court, because it is a procedure and not a rule of evidence. Then coming to ambiguous document. If a document is vague, because after 92, we go to 93, 95 to 97. I'll rush through two judgments and try to close. Keshav Lal versus Lalubhai Patel, AR 1958, Supreme Court, page 12. You cannot let in any evidence to remove the ambiguity. If it is there is two types of ambiguity available. One is patent ambiguity and a latent ambiguity. If it is a patent ambiguity, you are not permitted to let in any evidence. The reason is, when the document is there, and if the ambiguity is on the face of it seen, then you cannot supply any term. If the ambiguity is latent, that it is hidden, then you can give some explanation about the ambiguity. Straight away, Kyorimal versus Union of India, AR 1959, Calcutta, page 430. Kyorimal versus Union of India, AR 1959, Calcutta, page 438. That was a case where there was a contract of arbitration clause. This arbitration clause shows arbitration has to be done by the superintending engineer or / assistant superintending engineer, chief engineer or assistant chief engineer. Normally, one has to be struck off. It has not been done in the case. Inadvertently, it was left out. But the court said, on the face of it, you can read it. It is a patent ambiguity. Once there is a patent ambiguity, you cannot supply any words. The contract is void for uncertainty. You cannot enforce. But if it is a latent ambiguity, you can let in evidence. How it is possible? Ramachandra versus Chairman. Ramachandra versus Chairman Rajgir. AR 1965, Patna, page 174. Ramachandra versus Chairman Rajgir, AR 1965, Patna, 174. A person was named as a member of a committee, notified committee, if I remember. This, by the description of a person's name, there were 3 persons in that particular place. The court said, identifying a person of the 3, which one has been made as a member of the committee. It is not a patent ambiguity. it is a latent ambiguity because it is not available on the face of the record. Person's name is right, but who is that person for which you can let in evidence on the basis of latent ambiguity? Then coming to 2 or 3 cases which I would like to, when there is a conflict between the descriptions or the dimensions, boundaries will prevail over extent of the property. How it is possible? Can you let in evidence? AAR 1949 Privy Council was a case on that point. PKRCO Society versus the Government of Palestine. And in fact, even before that, the law was settled before this court for at least for 70, 80 years. That has been reiterated by the Privy Council judgment. In that case, quite interestingly, there are only 2 boundaries. Don't think that there is required 4 boundaries. Order 7 Rule 3 speaks about boundaries. The property has to be identified either by boundaries or survey number. It need not be 4 boundaries. It can be even 3 boundaries. Therefore, the court in 49 Privy Council held that there were 2 boundaries correct in the document. On the basis of these 2 boundaries, the property can be identified for which you can let in evidence. Then, if there is a conflict between the terms in the document and a degree, which one will prevail? Everybody will say that it is a degree. It's not so. If there is a conflict between the document and the degree, the document will prevail. Suppose in the plain or something document you are referred to, the measurements are given in the and the degree it has been mistakenly given as something else. Then you can let in evidence to show that the document is correct and not the degree. Kalicharan versus Hari Ram, AAR 1958 Punjab, page 13. AAR 1958 Punjab 13, where the Lordship would say that if there is a conflict between a document and a degree, document will prevail. In case of a conflict between text and map, text will prevail. Namely, there is a document, and to the assuming for a sale deed, there are you attach a sketch of the plot, and there is a discrepancy between the sketch and the document, or the recital in the document. The document will prevail over the sketch. We don't have any direct judgment on that point from India. We have an English judgment on that. Home versus Trubin, 1902 AC, page 454. 1902 AC, page 454. To sum up, section 92 gives a bar, but always there are ways and means to circumvent the bar of varying the terms of the contract by fitting your case under the proviso. The proviso is all the more important because it speaks about in case of a want of capacity to execute the contract, or the incompetent or want of consideration or failure of consideration, or a subsequent oral agreement, etc. Therefore, 91 and 92 have a far-reaching importance insofar as the trial courts are concerned, where you let in evidence, be thorough and be what you say that if you want to let in any evidence against a contract, try to fit in the case, whether there is intention. As his Lordship Melville says, don't start with that you can let in evidence, but by conduct of parties, you can turn the tables otherwise. Thank you very much.
Yeah, Mr. Prabhakar. 2 facts always fascinate me. The way you can hit the legal jargon and legal facts along with the comments on your own, even to state to that effect that this judgment requires reconsideration, and spot on without looking at the papers. I sometimes believe that we should have one webinar as to how you can remember all those facts, for a young lawyers at least, who can remember the facts and juxtapose with the judgments at the relevant time, along with the sections, etc. Since I'm slightly busy, but before I will not be taking the questions because I have to go somewhere, but commitment is a commitment. I will just read two views. One from the Pakistan. He says, Irfan, it's on the YouTube, Irfan Ahmed. Assalamu alaikum. That is wishes. Very nicely briefing. Sir, hats off to you for taking this session in such a nice manner. And then then the rest are the questions, but because of paucity of time, I will not take the questions. And this gives our the impetus that we can request Mr. Prabhakar to take things forward in some other aspects. And the way people have taken it up on the YouTube, I can say that it will be one of the sessions which will be actually zoomed up. Though we are on the Zoom, but the session will is actually showing the dynamics of zooming up. So thank you, everyone. Stay safe, stay blessed. And we are always so lucky and blessed that Prabhakar, whenever we ask him to take the sessions, he takes, and that too, juxtaposition of various sessions, various sections, various judgments. That is his beauty. So he's what we say that initially we should say you have to have an all-rounder who can take everything. And Mr. Prabhakar is like that. Thank you, everyone. Stay safe. Thank you.